Morning, Your Honors. The matter before the court this morning is the case entitled In Re MM, case number 23 AP 332. Representing the appellants CM and RM is attorney Sharon Jo Gentry. Present with attorney Gentry is attorney Sarah Starr. Representing the appellee, State of Vermont, is attorney Kaylee Olson.
Thank you very much, and good morning, counsel. Are the lawyers for the appellant splitting time up, or just one of you arguing?
Your Honor, I'll be arguing for both appellants. Although Ms. Starr is available if there are specific questions relating to father.
Okay, thank you, Attorney Gentry. Please go ahead then, introduce yourself and your clients, and then proceed.
Thank you, Your Honor. Good morning. My name is Sharon Gentry. I'm representing appellant's mother and father in this matter. And may it please the court. The trial court erred in adjudicating M.M. Chin's in this case when the state did not meet its burden to prove that she was without proper parental care at the time of the petition. And while the state may seek a temporary care order based on concerns that is not yet fully investigated, the merits hearing is a time when the state is put to its proof, and it must prove and it must meet its burden to prove that the child was without proper parental care. Initial concerns are not a basis on which to find a child Chin's. And in this case, the state did not meet its burden.
Ms. Gentry, can I ask a question right off? In the brief, you or Ms. Starr, both of you, there was a statement that the court had made a finding that the mother had locked her gun away prior to the petition. And as I read the order, I saw numerous times where the court said mother testified that she did X, Y, and Z. But could you just cite for me where it says that the court found that she actually didn't have her gun locked up at the time of the petition?
I do recall, Your Honor, that the unrebutted testimony was that mother had locked up the gun and testified to that, although she had not confirmed that to DCF. I don't have the pinpoint site here to the order, but given that that was mother's testimony and there was no contrary testimony to that fact, it seems as if the court sort of almost by implication made a finding, because it did note that mother testified that she had done so, and there was no other contrary finding or contrary testimony.
Okay, thank you.
While DCF may have a concern which is based on not factual evidence cannot form the basis for a Chin's finding. In this case, the parents, the daughter had a mental health crisis. The parents sought appropriate treatment for that. The daughter went to Rutland Regional Medical Center where she was discharged after 1 day. She then returned home for approximately 10 days where she was under the care of her parents, and the parents had locked up the gun and in a closet and then also in a car. It was after that 10 days that the child then returned to Jarrett House where she entered crisis stabilization. It was at Jarrett House that the concern about the gun being locked up was brought to the parents. And while the parents would not confirm with DCF for their various reasons, unrebutted facts are that the guns still remain locked either in the house in a locked closet with a lock, or in the car with the ammunition stored separately. And while their DCF may have had a concern that the child was at risk of harm, in actuality, the child never was, because the child never had access to the gun while she was either at home or when she returned home.
Ms. Gentry, the child was aware that there was a gun in the mother's room, either in the closet or in the drawer or someplace combination thereof, correct?
Yes, Your Honor.
And the child did make statements regarding the use of the gun on her mother and on herself. That's undisputed testimony, is it not?
Correct, Your Honor. The child did initially make statements, was then stabilized, was discharged as stabilized, and then returned home for 10 days, and then went to Jarrett House.
So, Ms. Gentry, can you tell me where in that timeline regarding father's testimony that he stated the child could, in his opinion, access the gun if she wanted to?
I think father's statement was that if she wanted, essentially, was that if she wanted to hurt herself, she would find a way. Even if the parents took reasonable steps to keep the gun from the child, that she would find a way. And again, there are only, the mother had locked the firearm up, had put it in the car, locked it in the car.
So can I ask you, why wouldn't mother just disclose that to DCF?
Your Honor, my sense from reading is that there was a bit of a power struggle between the DCF worker and the mother, who is a police officer. I think father described it as two very strong women who are sort of used to getting their way and doing things the way they want to do them. It's unfortunate that the inability to communicate brought this matter to where it was, but even so, it at no time was the child at risk of harm.
But that information may be true, but it was information that the parties had and didn't share with DCF. And doesn't DCF have to go on the information that they have, not information someone else has but won't communicate?
That's true, Your Honor. I think they can open an assessment or an investigation, but it's incumbent upon the state it's their burden to prove that the child at the time of the petition was at risk of harm or being harmed. It's not up to the parent to disprove a non-factual, factually based concern that DCF has. DCF easily could have done further assessment or done an investigation, and perhaps even a temporary care order to elicit that information. But at a merits hearing, the statute is very clear in terms of you have to show that the child was at risk of harm or being harmed. And mother's compliance with DCF doesn't necessarily, or lack of compliance doesn't mean that the child was at risk of harm or being harmed. On the opposite side of the coin, if mother had complied with DCF's request and said, absolutely, my gun is locked up, I'm engaging with you, when in fact the gun was not locked up, we wouldn't be here. And yet the child would have actually been in a harmful position. So in terms of compliance by the parents, it's one factor in looking at it in an assessment or investigation, but it's not relevant to whether the child was actually at harmed or risk of harm.
Ms. Gentry, would it matter if the child hadn't been specific about the gun, saying that she wanted to do harm to the mother without using any specific weapon, saying I'm going to do harm to you, mother, and I'm also going to do harm to myself. Did the fact that it was specifically the gun that was mentioned, does that make a difference in the analysis?
I think only to the extent, Your Honor, that it's what is being focused on, but I don't think it makes a difference in the analysis of the merits about whether or not the child was actually at risk of harm. I think it might make a difference in an assessment or investigation in terms of the focus of what DCF was looking for or concerned about, but I don't think it makes a difference in the final analysis.
Thank you.
What's the relief that you're seeking here?
Your Honor, we would ask that the court overturn the Chin's adjudication.
Would you like to talk about the standing issue that was raised by the state?
Yes, Your Honor. The appellants, this is a case where the negative collateral consequences doctrine applies. As we noted in Ray CH and also in Hinkson, both of those cases referenced that in a family court matter, a Chin's adjudication it could become relevant again, or in Hinkson, may affect other legal proceedings. And we believe that's the case here because the parents are currently in a custody or divorce proceeding in which a determination of parental rights and responsibilities and parent-child contact are being considered. And the language in both CH and Hinkson is, I believe in CH is, could become relevant again if either party seeks to modify custody. And in Hinkson, the language is may. And so based on both of those cases, the Chin's adjudication certainly may become relevant in the family court case. And given that it's an adjudication, I understand that certainly the parties could talk about the behaviors, but once you have an adjudication that the behavior of one party rose to the level of basically neglect or harm under Vermont statutes, I think that the trial court then is also sort of guided then by the idea of the finality of judgments and collateral estoppel, res judicata, and that even if the trial court in the divorce believed that the behavior didn't rise to that level, it's bound by the Chin's adjudication that was found prior to the divorce. So it certainly can come into play in determining which parent retains custody and which parent, what the parent-child contact schedule looks like.
Thank you.
If there are no other questions, I would like to reserve the rest of my time for rebuttal.
Yes, thanks very much. That's certainly fine. I see no hands, so we'll turn to counsel for the appellee. Please introduce yourself and your client and then proceed.
Good morning, Your Honors, and may it please the court. My name is Kaylee Olson, and I represent the state of Vermont in this matter.
Would you speak up? Can you get closer to your microphone, please?
Yes, Your Honor. Is this better?
That's better.
Thank you. I apologize.
That's
First,
right.
the state is challenging the standing to bring this appeal because the state believes this appeal is moot. A case is considered moot if no live issue is presented. And in this case, the family court's jurisdiction terminated on October 12th, 2023, when the court issued a disposition order calling for a full return of legal custody of the juvenile back to her parents. And it was not until October 18th, 2023, that mother and father appealed. Understanding that mother and father are stating the negative collateral consequences doctrine should apply as an exception to the mootness doctrine, the state believes that the negative collateral consequences doctrine does not apply. The state primarily relies upon two cases, Your Honors, State versus JS and Hinksons versus Stevens. Those are two cases in which the Supreme Court did apply the negative collateral consequences doctrine. However, in State versus JS, the court primarily focused on the fact that being adjudicated as a person in need of care and treatment as it relates to being mentally ill and then continuously involuntarily hospitalized is something that would continue to plague the appellant with a social stigmatization. The state does not believe a Chin's adjudication carries that same social stigmatization that mental health from being adjudicated as a person in need of care and treatment does. And Hinkson versus
Ms. Altman, under
Go ahead.
oh,
No, go ahead.
okay. So under 33-5117, the court can issue an order releasing records when there's a person with a need to know. So imagine that mother decides to leave her law enforcement job that she's at now and go to another one, and there's a background check. I can see where it might be reasonable for a court to release that to an agency like a law enforcement group in order to determine whether she's fit for a job. I mean, I think that's what worries me most about the collateral consequences, is that the court always has the right to release this information to someone that the court deems needs to know. So how would you respond to that?
Absolutely, Your Honor. So although the court may release records, I think the key word that the court has to focus on is may. It's not an absolute that these are records from the juvenile proceedings that would be released either to another law enforcement agency or, for example, to another court for a pending divorce proceeding. In those types of cases, it would require a filing upon the motion of the parties to the court, and the court may or may not release them depending on whether the court thinks it's fit.
Right, but it could happen.
And even with could, Your Honor, I do think an important distinction with the negative collateral consequences doctrine is that In re Moriarty states that a mere possibility of a negative collateral consequence is insufficient to trigger the exception to the mootness doctrine. And from the state's perspective, a possibility or a could of releasing those records falls under that mere possibility that the court would not extend the negative collateral consequences doctrine to. Understanding that that mother and father are relying on In re CH, which was a decision that the court used for the negative collateral consequences doctrine, I would note first that In re CH is an unpublished decision and is not as persuasive for this court. Furthermore, although unclear from In re CH, from my read of it, it seems as though the disposition order in that case modified a pre-existing parental rights and responsibilities order, and therefore at disposition, it became a part, or the juvenile case became a part of the ongoing divorce proceedings. That's not what occurred in this case. There was no prior PR&R whereby if the court made any sort of, the juvenile court made any sort of modification of that PR&R, that it would have to be made a part of the ongoing divorce proceedings. That simply is just not here, Your Honors. And so for those reasons, we don't believe that the negative collateral consequences doctrine should be applied here and that this case should continuously be found as moot. However, if the court disagrees, the state does believe that the family court properly exercised discretion in adjudicating juvenile MM as chins because the evidence in the record supports the finding. Here, the appropriate standard of review is abuse of discretion. In re ME states that the court's role as an appellate court is not to second guess the family court to make its own assessment of the evidence, but rather to determine whether the court abused its discretion in resolving the chins. From the state's perspective, we believe that the court came to the appropriate conclusion based off of what was within the record. Mother and father argue that the trial court found no risk of harm towards the juvenile. However, in the trial court's finding in the merits, it stated at the time of the petition, DCF's concerns about gun safety were real. Mother actually had a gun in her possession. Mother had previously stored the gun in her home. Juvenile had had prior access to mother's gun in the home. Father believed that my juvenile MM could access if she intended. Mother refused to confirm that the gun was now being stored safely. And here, refusal reasonably gave rise to the conclusion that it was not being stored safely, putting the juvenile MM at risk of harm.
And Ms. Olson, at the time of the filing of the petition, it is by a preponderance of the evidence, correct, that the court has defined that there is risk to the child?
That is correct, Your Honor.
Thank you.
Mother and father claim that this case is similar to what the court found in Re AO. However, primarily focusing on the fact that parents' non-compliance with DCF's safety plans or recommendations is not enough for a finding of chins. However, in Re AO, the court was more specific than that, stating that general non-specific findings is not enough to be found for merits. Here in this case, although there were concerns that mother was refusing to comply with what DCF's recommendations were, the court found much farther than that, than just besides DCF's concerns that they had. The court found that there were real concerns as it pertained to the juvenile. These concerns related to this was a juvenile who had made homicidal and suicidal statements wanting to specifically use her mother's gun as a means of harming herself and others, that there was a history here where the juvenile had previously accessed the gun, that father had testified and the court accepted and put in its findings that if the juvenile wanted to harm herself as it related to the gun, that she could, and that mother's refusal, not only to DCF, but to Jarrett House, which was the Stabilization Crisis Center charged with caring for the juvenile, all related to the fact that the juvenile was in fact at risk of harm. Further, the court also found, not only as it related to the gun issue, found that there were inadequate mental health supports that were put in place despite the recommendations for having mental health supports. Understanding that mother states in her reply brief that mother has discretion of wanting to find a care provider for her juvenile and should be allowed to find that care in what she sees fit. Here, we're dealing with a juvenile who was making homicidal and suicidal statements. The only supports that mother had in place at the time was to put her on a waiting list for a previous therapist. Jarrett House was offering mother supports in place that would get the juvenile immediate attention so that upon her discharge, she would have the appropriate supports put in place. Based off of both the gun safety issue and the inadequate mental health supports, the court appropriately found that the juvenile MM was at risk of harm. Parents claim that the state is required to exhaust all other resources when filing a CHINS petition, including should have explored an extreme risk protection order in this matter. That simply is not true as it relates to a CHINS petition. Although it is true that DCF is forced to make reasonable efforts as it relates to temporary care and the emergency removal of a child, the state would have still been within its right to file a CHINS petition even on a non-emergency basis. So for those reasons, the state does not believe this is a relevant argument as it relates to the merits of the case. And finally, although the trial court misstated the law at the beginning of the trial court's decision, the misstatement of the law was merely a Scribner's error. The court's analysis, the court's focus on the facts, and the type of facts relied on give an indication that this decision was made with the legal standard of merits in mind. Specifically, within the court's decision, it defined what a child in need of care and supervision was. The court only relied on facts that existed at the time of the petition. It discussed the risk of harm of parents' actions as it related to the juvenile, And the court concluded its decision by stating the correct legal standard. Mother and father also rely on In Re AO, where the court noted that the trial court in that case had stated the wrong legal standard and was not willing to give the deferential view to the trial court based off of its misstatement of the law. However, the In Re AO case had a merits decision where it continuously discussed whether or not it would be appropriate for the child to return safely to the home, which is certainly a temporary care or a disposition standard. In this trial court decision, no such discussion is made. The court continuously only focuses on whether or not the child at the time of the filing of the petition was in fact a child in need of care and supervision. So this court should find confidence in the trial court's decision because the analysis and facts are all consistent with that of a merits legal standard. If there are no further questions, the state would rest on its brief.
Okay, thank you very much. How much time does the appellant have, please?
Appellants have 2 minutes and 5 seconds remaining, Your Honor.
Counsel?
Thank you, Your Honor. To address first the standard of review, it is abuse of discretion for the findings of fact, but the conclusions of law, the court can review de novo. An appellant would argue that even if everything in the petition was proven correct, was true, that still under the Chin's statutory scheme, that there should be no finding that the child was harmed or at risk of harm. Secondly, the state again used the language that concerns were real, mother refused to confirm, but at no time has the court found that the gun was in the home, was accessible to the child, or that the child was in any way harmed. Thirdly, the timing. This was not an emergent situation. The child had gone to the ER, had been stabilized, was home again with the parents for 10 days. It was only the parents getting appropriate care for the child and putting the child in Jarrett House because they were doing the appropriate things as parents that this issue ever came up. And it's unfortunate that by seeking help for their child, they were then put into a position where because they would not comply with DCF's requests, that they end up in a Chin's case.
So the Chin's allegation, the fact that the mother would not give disclosure to DCF about the location of the gun or agree to put the gun outside the house, is that the actual act of without proper parental care?
Yes, Your Honor, that's what we believe, yes.
Thank you.
And I see my time is up.
Okay, thank you both. Please call a conclusion of the hearing.